next to look at what is a major life activity. And again, a very broad definition of what's a major life activity. Caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, ding, 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 ding. Okay. You're in the club. Walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, working, bodily functions. And because my practice is primarily representing employers, I start with the presumption. If one of my clients comes to me and they say, we've got a problem with an employee and they're claiming they need something with respect to their working conditions because of a problem, a physical or mental problem that they're having, I give very little consideration to the issue of whether they are disabled. I start with the premise. We're going to have to assume, for purposes of working the problem, that the person is in fact disabled under the federal law. Because again, major life activities, very broad. If there's a problem, it's probably going to be a disability under the current state of the law. Any disorder is likely an impairment. All employees with an impairment are likely to be referred to HR to determine what action needs to be taken. And then the HR will work through the process. And so this is the world we live in, where only in extreme cases are we going to stop at the outset and say, no, wait a minute. That case of the sniffles that you have is not a disability. But if it's something more serious than a cold, we're going to have to look very seriously as to the next part of the process. And that is, now, is the person qualified? So we've got an employee, they're disabled. Now, is he or she qualified? Because the law does not allow employees to say, okay, I have a disability, so I'm going to come into work and lay on a cot in the back until I feel like working. And maybe some days I won't feel like working at all, but I'll still expect to be paid. That's not the world we live in. And that's not what the ADA does. You still have to do your job. Okay, so full definition is a qualified individual with a disability. So do they have the requisite skill, experience, education, and job requirements? So the person is qualified. If they need a license, they've got the license. If they've got a skill set, they've got the skill set. But now the question is, can they perform the essential functions of the job with or without reasonable accommodation? And here's where employers get confused or get reluctant. And here's where employees sometimes try and take advantage of the situation. The individual with the disability may be required to be provided reasonable accommodation to perform the essential functions. But they have to perform the essential functions. Now, I had a case a few years ago where an individual had a back problem, chronic, and they worked on an assembly line. And there were 5 stations on the assembly line which were rotated among the employees. And one of them required lifting. And what the employee said was, I don't want to do any lifting. I'll do the other 4 of the easy stations, and the other employees can do the lifting for me. And that's the reasonable accommodation that I want. Well, on a certain level, maybe that makes sense. I'm not sure the other employees were that thrilled about the idea that all of a sudden they were going to have to do the lifting for that employee. So the matter got litigated. And what the court said is, no, that employee was wrong. The employee has to perform the essential functions. Now, could the employee be in a position to say, I want a lifting device, or I want a lifting belt, I want something that will help me lift, that the employer has to pay for? Yes. But the employee does not get to say, okay, there are 5 stations, I'm only going to do the 4 easy ones. That's changing the job, and that you cannot do. You still have to perform the essential functions, even if you're disabled. There's a whole set of cases, and PJ may choose to make reference to these sometimes in certain situations, because they are referred to as the boss-ectomy cases, where the employee says, I have a disability, I have a stress condition, and the stress condition is being caused by my boss. Therefore, I want a different boss. That's the reasonable accommodation that I want. I want a boss-ectomy. And I'm sorry to tell you, PJ, but those cases have gone down in flames. The courts have said, no boss-ectomies. That's not what we're talking about. We're talking about the reasonable accommodation. The essential functions include having to deal with the boss that you're given. So the job functions, though, are not necessarily everything that the job requires. There are trickier cases. I had a case a few years ago where an employee, and this is actually fairly common, employee said, I need a chair. I'm at a counter, I'm at a cash register, and when I'm not servicing a customer because of my back condition or leg condition, it was a leg condition, I need a chair. And the employer said, I don't want to give that person a chair. It doesn't look good. The aesthetics are not nice. And I think it's an essential function of the job that they be able to stand. And it probably was an essential function that the person be able to stand to reach the counter, to get access to the cash register. But was it an essential function that they stand all the time? Yeah, you know, no, it was not. And then he said, and then the employer says, well, if I have to give her a chair, I have to give everybody a chair. I don't want to do that. I don't like the way that looks. And to which I replied, no, you don't have to give everybody a chair. You only have to give the disabled employees chairs. That's what it means. It's a reasonable accommodation for disabled people, not a reasonable accommodation for able-bodied people. So, as angry as the employer was about this, and it's funny how often employers get really angry about these reasonable accommodations. That was absolutely what had to be done. That employee got a chair because that employee had a disability, and that's the way it works. Operating the cash register was an essential function. Standing all the time was not an essential function. But you can see now how nuanced this is. You really have to think about the job. You have to break it down and say, what are the actual key components? Job descriptions are very important in these situations. So you enter into an interactive process. And I still can't believe how many times I come on to a situation where a lawsuit has been filed and I say, let me see the notes of the interactive process. And there were none. There were no discussion whatsoever of how we're going to work through this, what was proposed. And this is a terrible missed opportunity for employers because the way the law works is this. So the employee comes in, PJ comes in and says, David, I need the reasonable accommodation of, I want 4 male bearers to carry me into work every day. And I want them to be good looking. Because that's what I need to deal with my condition. And so I say to PJ, well, PJ, I'm sorry you have a disability. I want you to perform the essential functions. We are going to get you a reasonable accommodation. But the 4 handsome bearers to carry you in and out of work every day, that I believe not to be reasonable. But here's something that could be useful to you. You've got a narcolepsy condition. You can play some energizing, happy music in your office that would otherwise annoy me. But as a reasonable accommodation to help you stay engaged, I'm going to let you play some really nice music. And she says, no, I want the 4 male bearers. That will get me energized all day long. Here's the key, and here's the opportunity missed for employers. You work through the interactive process, and you get a doctor involved. You get what the doctor says. But at the end, if there are 3 reasonable accommodations, and presumably PJ's found a doctor who has blessed the 4 handsome male bearers, and I found a doctor who says, no, all she needs is some perky music in her office. the employer, not the employee, gets to pick which reasonable accommodation is going to be used that has been sanctioned by a treating physician. And so employers hold an ACE card that they foolishly throw away when they don't engage in the interactive process. So again, possible accommodations. There's no end to the creativity that can be used here. And again, to the chagrin of employers, the bigger the employer, the more expense that is going to be permitted to be imposed on that employer. So when they talk about reasonable accommodation, the regulations make clear, and this has been true from the outset in 1992, that it may require a real expenditure of money. It may mean that the employer has to go out and buy an expensive ergonomic chair. It may mean that, they gave you the example, in a large corporation, you might have to have somebody read for a blind or sight impaired person. You hire a person to do that, to be a part-time reader. So it can involve significant expense. Now, there can be restructuring at the margins, but remember what I said earlier about no essential functions can be eliminated. That's off limits. Modified schedules, if reasonable, reassignment to an open and available position, if it's available, no bumping. What is really a hot point now, if you really want to stick a hot poker into an employer, you tell the employer that I need time off to reasonably accommodate my disability. And the law is very much in turmoil right now because judges have said the whole point of the ADA is so people can do their jobs. You're supposed to be able to accommodate somebody so they can come into work and work. So we want to do whatever it takes for the person to be in their chair or at their station working. So the idea of somebody getting leave under the ADA as a reasonable accommodation to them is an oxymoron. It makes no sense. I'm going to give somebody something and they're not going to be there. No, I want them there. And the EEOC though has said, well, you're wrong. And there's got to be an opportunity for people to take some leave, to take some breaks, and to accommodate their condition. So you've got the EEOC saying one thing, you've got the courts saying a different thing. The Seventh Circuit just issued a ruling this past week that said that as far as the Seventh Circuit is concerned, if we're talking about a leave in the months as opposed to weeks, forget it. We are saying absolutely that's never going to be a reasonable accommodation under the ADA for people to be gone from work for months. But weeks, they didn't talk about that. In other cases, I said a week off here, a week off there, a flexibility in your leave policy for unpaid leave, that could be a reasonable accommodation. But there's a fight brewing. There could be another amendment of the law coming because this one has employers hopping mad. So again, at the end of the spectrum, the accommodations don't include anything that would be an undue hardship. They don't include tolerating poor performance, even if you've got a mean boss. They don't include direct threat to safety. I had a case last year where a person was climbing ladders and they were subject to dizzy spells. And again, what they wanted was the accommodation of no climbing ladders, but that actually was part of their job. 40% of their time was up on ladders and bridge work. But the law is clear. If you are a threat to yourself or to others, that is an undue hardship. That renders you otherwise unqualified for the job because we couldn't have an employee falling on people. Yes, sir?
What constitutes an undue hardship? Who gets to make that decision?
Well, the courts ultimately make the decision. The undue hardship is going to be analyzed by the decider of the law in a lawsuit. But the employer, just because the employer says it's an undue hardship doesn't mean it's so. The employer is going to have that decision evaluated in a lawsuit if it comes to that. But the two, I'd say the three hard stops are something that would be an exorbitant expense. would be an undue hardship. I would argue that the 4 handsome male bears of PJ would be an undue hardship because I think those are pretty expensive last time I checked on the cost of those. And, but then also if somebody is risking injury to workers or to themselves, that's an undue hardship on the employer to take that risk and frankly to put the other employees at risk in that fashion. That's an undue hardship. And the court, because we have all these cases since 1992, we have a whole set of cases where the courts have said, here are examples of undue hardships that we're not going to categorize as reasonable accommodations, and we're going to agree that the employer correctly concluded that the remedy for the situation was to terminate the employee because they could not do the job safely. And so again, if it wasn't tricky enough for employers, at the end of all this, they also have to maintain privacy. And there are obviously HIPAA laws as well on that front. And people, you have to do this dance where you have to explain, well, we have to do this reasonable accommodation. And the supervisor wants to go, well, why? What's wrong with them? Well, it's really none of your darn business. What's wrong with them? Here's what we need to do. And now, if the person wants to disclose their condition, so be it. But it's not up to the employer to publicize or, again, because that funnels back to the notion of no harassment, no hostile environment, no making fun of people because they're not, perfect. So, this is the world we're living in. It's one that, frankly, is very supportive of narcolepsy and narcoleptic conditions, as long as you know your set of rights, as long as you don't overplay your hand, you can have a situation where a person with narcolepsy can demand as a legal right that they be reasonably accommodated. You're not trying to dodge any essential functions, but acceptance of a need to take time for medication or to accept some side effects from medication, well within your legal rights. Yes?
So I've been at my job for 1.5 years now, but didn't disclose when I first got there. And so, from what I understand, so when you disclose doesn't have anything to do with the reasonable accommodations. That can be there for 1.5 years and still need reasonable accommodations.
That's a great point. And some of the back may not have heard that. There's no statute of limitations, if you will, on your disclosure of the fact that you have a disability and need a reasonable accommodation. You don't have to do it when you start your employment. You don't have to do it as part of the application process. You do have to be in a position where you can say truthfully that you can perform the essential functions of the job. You can't be a blind person applying for a job as a driver of the company truck. But as long as you can perform the essential functions of the job with reasonable accommodation, you don't have to disclose anything. At any point when you feel that you need a reasonable accommodation, then you can come forward and say, I have a disability, I need a reasonable accommodation, and here's what I need, and then start the interactive process. Yes, sir.
I've gone through the whole thing. I had accommodations removed and ended up being discriminated against. My question is more about, I went through Department of Human Rights, EEOC, and again, they didn't find it as disabling. Got their letter to sue, but stopped at that point. Can you describe the process so that if I or someone else is in that position, what to expect?
Yes, the question is, what is the litigation process under the ADA? And the way it works is this: you file with the EEOC, the Equal Employment Opportunity Commission, a claim that you have been discriminated against on the basis of a disability. And I recommend that you do that within 90 days of the discriminatory event. Depending on what jurisdiction you're in, it could be 180 days or it could be 300 days, but I would not wait. 90 days is a safe harbor. The EEOC investigates it. They've had a cutback of funds, and so what they're really doing now is they're just kind of waving their hand over it, and they very rarely find cause. In an extremely small percentage of cases, they will take the lawsuit themselves, and the EEOC will file a lawsuit against the employer. But far more common is they will just issue what's called a right to sue letter. And then once you get the right to sue letter, then from that point forward, you have, I recommend within 60 days that you get a lawyer if you haven't got one already, and then you file suit, and that suit is in federal court. Yes, sir, ma'am.
What is the condition of the job? So you're hired seasonally. There's an arbitration clause.
The question is, what if there is an arbitration clause? And that issue has very recently gone to the U.S. Supreme Court, and the U.S. Supreme Court has found those arbitration clauses to be binding as long as the arbitration procedure is no more detrimental to the employee or no more expensive to the employee than a court process. So you would want to look at the arbitration provision to see if it's legal, because a lot of arbitration clauses are not legal. But if they are, then you would arbitrate it instead of taking it to court. And that is a right that you can't waive. I don't recommend that you do that, because you're going to be better served by having a jury trial than by having an arbitrator. But that's the current state of the law. And they do that because they feel it's in the interest of judicial economy. To finish though, what happens then once you file a federal court lawsuit? For example, in Indiana right now, it takes about 2 years to litigate a federal court lawsuit, but the statistics are pretty good. A disability discrimination plaintiff wins more than 50% of the time. There might be cases that actually get to the jury. Yes, ma'am, right here.
You said that if you're unable to do certain things in the job, like I'm a cashier, and occasionally I'm too tired, I can't do the use scans, but I'm like, I wouldn't be opposed to it. It would be a reasonable accommodation to just not be doing them, like, but I can do them aware.
The question is, if you work as a cashier and part of your job is to do scans, and sometimes you're too tired to do the scans, the question would be, is that an essential function of the job to do the scans? And that would be a function of how often they have to be done. Is that in the job description as one of the essential functions? If it's an essential function, you have to do it. More likely, if it's a situation where sometimes you can't do it, but as you were saying, a lot of the time you can do it, then you're going to look and see at what kind of business disruption that causes. If it doesn't cause any business disruption and it can be controlled to do the scans when you feel comfortable doing the scans, then that's going to be a reasonable accommodation. But if you're causing customers to have to wait and there's nobody to cover you, then the employer's got a better argument that you're trying to avoid doing an essential function, which the law does not permit you to do. So it's a very particularized analysis of the facts in your situation, in your particular job. I can see it going either way depending upon those other factors I talked about, and the size of the employer. Because the larger the employer, it's a graduated scale, the more the courts allow them, or the law allows them to be inconvenienced and to have to incur additional expense to accommodate you. Yes, sir.
Who do you disclose to?
Who do you disclose to? HR would be my choice for who you would disclose that to. You could do it to your supervisor if you have a sympathetic supervisor, but the law doesn't designate a particular person. Just anybody in management will do. Okay. Yes, sir.
I've been told that I have to get re-diagnosed with narcolepsy every 2 years. Originally, they told me it was every 1 year, and I got them to push it to 2 years.
Right. There are multiple laws in this area. This morning I've been talking about the Americans with Disabilities Act. There is also the Family Medical Leave Act. The Family Medical Leave Act has a definition of a serious health condition, and that gives you 12 weeks of unpaid leave per year mandated by law. So that's a completely different law. And under the FMLA, you are obligated to recertify your condition on a regular basis, because the FMLA doesn't distinguish between temporary and permanent conditions. Anything can be a serious illness or serious health condition. So they do have the right under the FMLA.
This was under a reasonable accommodation.
To recertify. Under the ADA, that would only be an issue if your condition is subject to clearing up. If it's a permanent condition, you should not have to recertify it. But because the law is expanded to include some temporary conditions, it would be appropriate in those circumstances to confirm that in fact you are still disabled under the law.
But narcolepsy, there is no cure. Get a new letter from your doctor stating it's a chronic condition and that it is
Right.
incurable,
Right.
that it will not change, and
If-
you have to get him to write that letter every 2 years.
Right,
It-
well, that's what we've come to,
yeah.
right, every 2 years, but because I've tried to explain to them that, and
Yeah.
Yeah,
Get a
well,
form letter he can sign.
if we're talking specifically about narcolepsy is a condition that with the right letter from your doctor, they should get off your back on that. And I'm a little concerned that they are harassing you to some extent to require you to recertify it when you've got the diagnosis.
well, you'd be more concerned to know who the employer is.
Uh-oh, maybe you better come talk to me afterwards.
So my question kind of fits in with that. And I'm asking more generally. My employer is great. I work for Narcolepsy Network. My employer's great. They're awesome. They really are. The question I had was more generally, what about retaliation that's not retaliation? For example, I have a friend with a different sleep disorder that had some tardies, got a note from the doctor saying, these are the tardies, now on medication, should be fine. Well, the immediate supervisor didn't like that and started being more nitpicky, little passive aggressive things, nothing that you can point a finger at, but it's still something that people will pull sometimes, or we hear about. My supervisor in HR are great, but the guy who I'm immediately reporting to, he wants me to tell him all the details. I don't want to tell him all the details, and if I won't tell him all the details, he's going to make my life difficult. We hear that a fair bit.
Yeah, my position is that retaliation is retaliation, harassment is harassment. I represent employees about 5% of the time for fun and profit. And what I do in those situations is I tell my client to start documenting immediately when that sort of thing happens and send emails. And I had one case against a very large company here in town, which I'm not saying the name of, although they deserve to have their name said, where we got into one of these email battles because the retaliation was ongoing. It was small stuff, but every time there was something like that, I had my client send an email saying, hey, I just got called out for the third time for something that everybody else does. I'm concerned it's because of my condition. And I finally ended up having a meeting with the general counsel for the company, and they said, go ahead and sue, your client's going to get 0. And my client did get 0, got 5 zeros with a number in front of it. And so that's how you do it. You don't put up with it. You document it, and if you get lucky, they'll fire you, and then you'll have a really good lawsuit.
Right, for those of us that don't want to have to go the route, or don't have the money to go the route of the lawyer, or don't honestly have the energy or the stamina to track down a lawyer that'll do it for us, is there any other recourse?
Well, again, your recourse, you're leaving yourself exposed by not documenting. And if you don't want to send the emails, the recourse is to file an EEOC charge, because you can't be harassed just because you're not fired. You cannot be the victim of disparate treatment on the basis of a protected status. So yes, you can file something with the EEOC. You can file a lawsuit. I guess you can go out and slash the tires of the supervisor's car in the parking lot, but I don't recommend that. And everybody on the camera, do not do that. I'm joking. So, it's all about documentation. My gosh, haven't we just seen the last 2 weeks with this situation about corroborating evidence and documentation, and the email world that we live in is your path to victory. To document contemporaneous documentation of misconduct is irreplaceable. Yes.
So if you have someone who's doing this type of thing and you park somewhere and you come in and there's people in the lobby and they say, you can't park here. And so you write a very nice little note saying, we'll discuss later at Narcolepsy attack. Give it to them. On your way back in front of your clients, they say, really? 12 steps? 12 steps make a difference? Is that like breaking the HIPAA?
Well, we could have a whole seminar on the HIPAA issue, but again, what we're concerned about here is a hostile environment. That's what you're describing as a hostile environment, and it's humiliation, actually, and that is against the law. You cannot create a hostile environment with somebody who has narcolepsy. That's the law.
And the catastrophe, it makes it worse, so then
Mm-hmm.
I do look at competences.
Again, document. Yes.
Who do you recommend sending these emails to?
You send the emails to your supervisor, or you can send them to HR. The law is you do not, I repeat, you do not have to make a complaint to your direct supervisor. You can make that complaint to anybody in management you feel comfortable making the complaint to. PJ.
David, what would you recommend for people to do to try to diffuse, or would the interactive process be restarted to try to open a dialogue with somebody in management to try to diffuse these kinds of situations?
Well, they are difficult to diffuse, but HR should be your linchpin. They should have the best understanding. You have a lot of management people out there who either don't understand the law or don't want to understand the law because they got to get the widgets made, and they want to be blissfully ignorant of their obligations otherwise. And so really HR should run point for you, and they should be the ones that should go to management and wise them up so that the company does not get hit with a big lawsuit. That's, you come to my seminars and I always talk about HR. They're the unsung heroes and heroines because they're the ones that prevent my talking about their company in my annual walk of shame. If you ever want to come to the Indiana Chamber of Commerce seminar that I chair each year. So that's the reality, and you're only, if you have a certain kind of supervisor, you're only going to make so much progress. It's HR, it's got to open up their eyes. Yes, sir.
What if HR fails to respond?
Well, then again, you're hiring a lawyer, or you're going to the EEOC or the Indiana Civil Rights Commission, or the Indianapolis Office of Equal Opportunity, and those are your remedies, short of the slashing of the tires, which you're not going to do.
Even if the employer is a government?
But yes, these laws apply to the public sector as well as the private sector. Absolutely.
Is it called something different?
It depends what kind of government entity you're talking about, whether it's federal or state or local.
And where you're located as well.
Oh, yes. This is a national conference. I've been talking about Indiana, but yes.
Yeah, so where you're located can sometimes make a difference as well. I'm from Commonwealth, so it's a little different there.
Yeah,
Commonwealth of Kentucky?
exactly.
Oh, Commonwealth of Virginia, we're neighbors in Commonwealth.
All right. See all right, a little bit of time. All right, any more questions? Yes, back there.
So,
All right, 5 minutes.
are you more protected? Is it better for you to make, like, have a notation with HR prior to speaking to your supervisor? Like, if you choose to speak to your supervisor, do you need to have the documentation in HR?
You can choose to speak to your supervisor if your supervisor is sympathetic. The problem is that oftentimes it's the supervisor that's the problem.
I see.
And what the law says is you don't have to go to this, you can if you want, but you don't have to go to the supervisor who's being ignorant of the law or being abusive. You can skip that step and just go straight to HR. And again, when I say document, I don't mean keep a private diary. Oh, he was mean to me today. I mean, you got to be noisier than that. You got to send a communication to HR, and you got to keep a copy for your file, a hard copy for your file. These are the communications I made that were ignored. So that's what you have to do to get the situation fixed. Yes, ma'am.
Can you give some examples of what reasonable accommodations for narcolepsy in a workplace can be? And I'll get a kind of job, but in general.
The question is, what sort of reasonable accommodations for narcolepsy could one imagine? I do think that this is a situation where micro leaves, if you will, the opportunity to, if you feel a narcolepsy attack coming on, it is not outrageous to say that you need a place to go. You should clock out because you're not working, frankly. If you're salaried, it becomes trickier. But again, the question is, are you performing the essential functions of your job? Are you making your deadlines? Are you getting the work done? If you are, then to allow you to, if you feel a narcolepsy attack coming on, allow you to take a nap at your station or something like that could very easily be a reasonable accommodation. Then you get employers say, well, I'm not gonna let all my employees take naps at their workstations. Well, all your employees don't have narcolepsy. And so this is a reasonable accommodation for somebody who has a medical condition, has a disability. Yes, ma'am. You're from the organization. You can give us a laundry list, right?
Yeah, I can give a list. I can also say, for anyone who's working retail, if you're going in a state that allows smoking, one thing I found that actually helped communicate why this was reasonable to employers with retail work is if you have an employee who smokes and they go out for a smoke break, they need about the same amount of time I would need to walk around the building to become more alert. That kind of helps them understand that it isn't an undue burden, because sometimes I think they, not knowing much about narcolepsy, many people think that we have these, that we just go and sleep everywhere for long periods of time. And so when you say you need a quick nap, they may not quite understand what you mean. Also, if you can give them I take a 20-minute nap or something like that, that can sometimes be helpful. Work shift work, you can ask not to be put, as long as everybody doesn't rotate shifts, you can ask not to be put on overnight shift. You can ask to have a chair if you're having to stand. You can ask for a spot where you can go, like, be allowed to go to the break room to rest. You can ask for breaks. You can ask to be put on another function of your job when, for example, your job is to do a spreadsheet, and when you're tired, you can't keep those columns straight, but you also need to collate something or get something printed. You can ask, when I get too tired to do this, may I go to the copier, have these copies made, or some other function of my job.
Overtime and the next people are waiting. I'm
Yes.
sorry about that.
So,
Sorry.
it was a great pleasure to be with you this morning, and good luck.